Hi, this is Scott Weavil, Principal Attorney with Weavil Law. Today we're going to be discussing term sheets, more popularly known as letters of intent or LOIs. There are basically three essential things that you need to know about LOIs. First, we're going to discuss what LOIs are and why you would use one. LOIs are basically the summary of a deal, including all the key terms for a transaction. They're used in all sorts of business transactions, from business purchases and sales to commercial real estate leases to executive employment agreements. Why would you use one? Well, using an LOI gives transactions a higher probability of closing because entering into one means that the parties have already agreed on key terms. It's obviously very smart to have agreement on fundamental issues before going to the time, expense, and distraction from your business of negotiating the more granular final agreements. Second, what are the key terms of an LOI? Well, on the business side, it's going to be the main deal points. So for something like a business purchase or sale, you should expect to see the purchase price, payment mechanics for the purchase price, representations and warranties, indemnification and any associated escrow, and other terms like non-competes. To give another example, for a commercial lease, you would expect to see information about the space, permitted uses and exclusive uses, the rental term and commencement date, the rental rate and how operating expenses are handled, as well as any TI allowance. Of course, that's just a glimpse. LOIs should basically include all the significant business terms. LOIs also include legal terms. These can be things like a no shop or exclusivity provision or an NDA or confidentiality provision. Third, it's important to understand what is and is not binding in an LOI. Usually key business terms, things like the purchase price, will be non-binding. So what's the point of entering into an LOI if the key terms are non-binding? It's because they set a baseline and expectations going forward. Absent big changes or surprises in diligence, you should not expect to renegotiate key business terms that are included in an LOI. Other terms, particularly the legal terms, tend to be binding. For instance, a confidentiality provision. Obviously, whether a transaction moves forward and goes to closing or not, the parties want to ensure that the sensitive information that they've shared with each other will be protected, and so the confidentiality provision will be binding. That's the basics on LOIs and why sophisticated negotiators use them. If you have questions or need help with an LOI, don't hesitate to reach out to us here at Weavil Law.